All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1 CACV 17-0326 in re the matter of Donald R. Schultz and Juanita Q. Schultz Living Trust. Counsel would remind you that we're recording these proceedings, so please identify yourselves and who you represent at the beginning of your arguments. Each side will have 20 minutes to present your arguments. Appellant's counsel, well, actually, both of you can watch the time. Since there is a cross appeal here, both of you can watch the clock and reserve as much time as you'd like for rebuttal. Again, we won't remind you, but it's your responsibility to hold a couple minutes or whatever you'd like for rebuttal. Also, please keep in mind we've read the briefs and discussed the case in conference. So without counsel for appellant, you may proceed.
Good morning. My name is Marguerite Kirk. I am counsel for the appellant, Eric Schultz, as well as the cross appellee, Eric Schultz. I would like to reserve approximately 5 minutes of my time for any reply argument or rebuttal argument. This case presents for this court actually probably a new judicial decision under ARS Section 14-10706 concerning the removal of a trustee, a co-trustee, for lack of cooperation in the administration of a trust and or an unwillingness or an unfitness by a pattern of repeated conduct in obstructing the administration, of a trust as a basis for removal. A subsidiary argument there, too, is the award of attorney's fees and costs under in Title 14, Section 11004. To begin, Donald and Juanita Schultz established a trust, their family trust, back in July 25th of 1996. They had 2 children, my client Eric, the appellee Marta Schultz. At the time, Marta and Eric were younger. They were presumably in a good familial relationship. The successor trustees appointed by Donald and Juanita were their children as co-trustees. Donald died. He went by the name Dutch as well. You'll see that in the pleadings. Died in February of 2012. Thereafter, Juanita began, she was the successor co-trustee, the initial successor co-trustee, and began an unfortunate decline mentally. She began to suffer from dementia. And in 2013, I believe it was, Eric, on his own, in light of his mother's declining mental condition, sought appointment of he and his sister Marta as co-trustees under the trust agreement. And therein started the problems. At the outset, Marta disputed that and objected to that appointment, but later relented. And as this court will note from the record in this appeal, that began and is, to this day, as far as I know, a persistent and chronic pattern of Marta's behavior.
And what was the basis of Martha's objection?
I do not know, Your Honor. I do not know why. I was not trial counsel at the time. I'm just appellate counsel. But my understanding may be that she did not believe that Marta was in a sufficiently mental condition or mental decline warranting. But what is important is she relented and agreed to the appointment. And that is important because...
Hold on, counsel. You're telling me the reason that sister here,
Marta,
objected to becoming effectively a co-trustee is irrelevant?
No, not that it's irrelevant, that I didn't know the answer to that question. I suspect it was that Juanita, their mother, did not have sufficient, or Marta may have believed that her mother still remained sufficiently competent to manage her own financial affairs.
Okay.
And Eric was of a contrary opinion. But what did happen was Marta did remove her objection, if you will, and they were both appointed successor co-trustees of their parents' trust.
But wouldn't that be a legitimate position to take if Martha really didn't believe that their mother was in such health that they should be appointed?
That may be, but I think what's important about it is that it establishes litigation conduct by Marta. It's the first instance of Marta objecting, relenting through litigation. And that has been to the sore detriment during Juanita's life. And now here we are again at the Court of Appeals on this issue concerning that. There have been multiple litigations between the party, and including, as you'll know from the from the briefs, there were corollary proceedings in Massachusetts when Juanita later moved to Massachusetts and lived with Eric and his family. And Eric was appointed the guardian and the conservator. He sought a petition in Massachusetts for that. Marta again objected and then withdrew her objection.
So let me ask you a question, counsel. Let's say your case is premised upon 3 instances of objecting, okay, litigation. The first one was meritorious, as it turns out. The second 2 were without foundation. Is it your position that we should include all 3 in our assessment of determining whether someone should, a trustee should be removed because merely they used the litigation process, even if it was meritorious on that first one? Or are we to focus on the second and third, which would be without foundation?
I think you have to look at it as a whole, and I'm not conceding that the first one was necessarily meritorious. I am simply stating that it shows a chronic and persistent pattern by Marta to interject objections that require litigation. She objects to the litigation and then ultimately walks it back.
But does it matter if it's meritorious, or does it?
I'm not, of course it would.
I'm not asking you if you're conceding. I'm saying just let's talk hypothetically.
Absolutely.
Does it matter?
Absolutely. It always matters if an action is meritorious, and we have rules that address that. But the point here is not so much did it have merit as what has it done, like what has been her pattern of litigation behavior. And as a result, that, I am suggesting to this court, establishes a pattern of perhaps unfitness or unwillingness to administer the trust for the benefit.
Let's talk about the next instance, right? So we have really, I think your case is premised upon a finite universe of conduct, or you might say misconduct, dilatory conduct. The first is the objection to the co-trustee appointment. What's the next one?
Thereafter, and so she agrees to the appointment, and thereafter the parties have disputes concerning, gathering the estate or the trust assets, itemizing them, financial documents, medical records of Juanita and whatnot. And part of it is there is the home in Cornville that Juanita resided in at the time, together with a rental property located also in Yavapai County. And the issue then became the administration of those assets, if you will. Now, the Cornville property was becoming, well, I don't want to say in decay, but it was not kept up, if you will, and was posing, I would suggest, a safety hazard to Juanita. On the other hand, the property that was being rented, the monies were not being gathered appropriately and placed into a trust account. The parties again, Eric tries again to get Marta to the table to work with him on gathering, itemizing these assets, and getting a plan in place for their administration, if you will, for their mother's benefit. Now, that's again, where problems arise. Marta becomes non-communicative. She delays, an 18th-month delay in opening a trust bank account for purposes of servicing that rental property, where the tenants can deposit the rent and whatnot.
And what is her position with regards to that? Do you know?
Marta's position?
Why does Martha take that position?
I think during the course of the trial, she alluded to a couple different issues that were causing delay. One was she was busy at work. She lives in California, and she was undertaking some additional work there. She was a teacher. She was busy. Eric lives in Massachusetts, but somehow he didn't have those same problems. Nevertheless, she also claimed when she received the documents from the credit union to open that dual signator trust account, that Eric had misstated whether or not the trust was revocable. He had written, as you will recall, revocable by Juanita with power of the court order, given her diminishing decline or mental capacity. And she disputed that and said it should be irrevocable. But therein, she never communicated that directly.
And ultimately, what was the correct way to identify that trust?
Ultimately, how was the account opened?
Who was right?
Yes.
Who was right?
Well, it sounds to me as if there were two positions taken.
Correct. And how was that account ultimately opened? I believe it was opened the way Eric had suggested, that it was revocable based upon, from the trial transcript, that was my understanding, that ultimately the account was opened. And he was the sole signature. She walked back her position again and said, okay, you can be sole signature on that account.
Did she, what's your opinion? Did she have any basis for her objection?
I think if you, well, I don't know. I mean, most people always have some basis. Whether or not it's a valid or a meritorious basis is always the question. And therein lies the rub, if you will. She would claim, I suspect, as opposing counsel has set forth in his briefs, that the trust became irrevocable upon Dutch's death, Donald's death. But however, that was never how it was treated. It was those two trusts, the AB trust and the marital situation, were never formally by Juanita herself upon her husband's death divided. So I think that if you want to look at the merits of whose argument was stronger, I would suggest that it was Eric's. He did nothing that was underhanded or untoward in terms of saying, well, this trust is revocable by my mother with court approval. If anything, there's an extra layer. I mean, he added on the extra layer of court approval to that.
So is your position that if your client was correct on that point, sister should be removed as a co-trustee, even if it's 51-49 and there's merit on both sides?
No, I'm never looking at just one, and I never have presented as just one individual factor as mandating or warranting her removal as co-trustee. It is a totality of the circumstance. You could potentially have, as have other jurisdictions, and I noted the Iowa case, where just one act alone, outside not counting a breach of trust because we weren't alleging that, where one act alone by a co-trustee can be so fundamentally detrimental to the benefit of the beneficiary of the estate that it warrants removal.
But you're not alleging that here.
No, we are not.
Okay,
what I
so
am
what's
saying,
the third? Let's get into the
The
third.
third one
Next.
would be, after that, it had to do with the cooperation of the sale of the trust real property, which was required by, or suggested, heavily suggested, by Massachusetts Benefit Planning Council, Public Benefits Planning Council. And Marta, again, no, we shouldn't do this, it should be rented, et cetera, provides, and here I will note, she provides no basis in the record at any time for her suggestion that that property should have been rented as opposed to sold. But what happens when we go to trial? She walks back her position and says, no, sale's fine, you go ahead and handle it. But in the interim, it doesn't account for 2 years' worth of litigation prior to that. Thereafter, we're looking at her trust management plan that she proposed in response in her answer and objection, cross petition, to the petition to remove her. And here, I think, is where things fall apart in any argument that attempts to support the decision of the trial court. And their claim that, look we're the prevailing party. The court largely adopted, and they use this term, I believe, no less than 5 times in their briefing, the trust management plan proposed by MARTA. But there's no legal basis for the court to rewrite the trust. These were not administrative practicalities of the trust. These were things that Eric must do, and what the carving out of oversight and veto authority to MARTA. And that's an entirely different structure than co-trustees typically have under a trust agreement. But at no time, and you'll never see it in their briefs, is there any mention of what is your legal basis for doing that. And therein lies the error of the court in adopting that as more or less a Solomon's choice in dividing the baby.
Counsel,
So there, if I understand you correctly, you're saying that the court had 2 options here. You either deny all relief requested or remove the co-trustee. And there's no middle ground.
Correct. Unfortunately,
is there a case law that Arizona case law that supports that?
No, this is the case law. This may be that case law. But under the statute and the way that it's structured with the legislature, it doesn't appear that there is that availability to a court.
Does that seem practical? I mean, why wouldn't the court have the ability to manage, to assist, manage, and sort of sort out the relationship as opposed to just blowing the whole thing up or leaving it as it is? It just doesn't seem very practical solution to go with the all or nothing approach.
But there's no statutory authority, and one would suspect that the legislature in adopting this uniform trust code provision would have made that calculus when it adopted it as it did. If the court had wanted to provide a trial court with oversight or the ability to blue pencil a trust, well, they could have very well have done that. But I have not seen any court in this country that did that, much less there being any authority under our statutory framework to do that. Your Honor,
Counsel, just one quick question. Are you seeking fees under 14-11004 subsection A or
Yes.
subsection B? Meaning, are you seeking fees from the trust itself or from your colleague, brother?
From what
sister, sorry.
From my reading of the statute, subsection A gives you the basis to request the fee as long as you have prosecuted or defended your case in good faith. B says it's up to the court to decide whether that come from the
Who are you seeking fees from?
I would say from MARTA directly. The trust doesn't have
So
sufficient
you're not seeking
funds.
fees from the trust, you're seeking fees from your
MARTA.
adversary.
Correct.
Okay, thank you.
Under like a bad faith litigation
Understood.
scenario.
Understood.
I have 3 minutes left, and I'll save that time. Thank you.
Thank you.
Good morning. I'm Mark Drutz. I'm here with Andrew Diener from Musgrove, Drutz, Cack, and Flack and Prescott, and we represent the appellee cross appellant in this case. Initially, this is not a case that was determined on a motion for summary judgment. This case was determined after a 4-day evidentiary trial in front of the Judge Butner. Each side had an ample opportunity to present their case, and although I wasn't there for the trial, I can tell you that the majority of the evidence was produced by the opponent, Eric SCHULTZ. Judge Butner required briefs, he had oral argument, and he ruled that Eric SCHULTZ did not sustain his burden of proof in removing Martha SCHULTZ, his sister, as the co-trustee. And then the case, Judge Butner then retired, and it was in front of Judge Napper, a new judge in Yavapai County. And Judge Napper entered an interesting minute entry exactly a year ago today. And he said, This case is ostensibly a fight about the administration of a trust. There was significant litigation and ultimately a trial. Recently retired Judge Butner conducted the trial. Judge Butner heard testimony, reviewed trial briefs before issuing his order. Judge Butner was in the best position to view the witnesses and make credibility determinations in reaching his conclusion, which was not to remove Marta Schultz, who had been nominated by her parents to serve as the co-trustee with her brother, Eric. And this court standard is abuse of discretion. And certainly, Eric Schultz is not going to be able to show, and hasn't shown, and I listened to the oral argument, there's been nothing presented either in the briefs or an oral argument that shows that Judge Butner abused his discretion in not removing the sister, Marta Schultz, as a co-trustee.
Let me ask you something, counsel. You argue in your briefs that your client reached agreement on various points during the course of litigation. Do we consider whether she reached agreement, or do we consider when she reached agreement? Meaning, is she not to be removed as a co-trustee if on the eve of trial or the eve of verdict concedes something that she previously wouldn't concede?
Judge, in this case, Eric Schultz, and these aren't my words, they're Judge Butner's. Eric Schultz is a bully, and there's only one way for Eric Schultz to manage a trust. It's his way or the highway. And he bullied Marta Schultz. He's probably bullied her for many years, and at some point, Marta Schultz tries to compromise with her brother Eric. And it wasn't just on the eve of trial. In August, before the trial, which I believe occurred certainly afterwards, she agreed to enter into a stipulated order regarding bank accounts, etc., and then Eric refused to sign the stipulation, and the case proceeded to trial.
Let's take a step back from the facts of this case and say we have before us two co-trustees, one sister and one brother. Sister should have done A, okay? We're just going to call it A. But she never did A, and it required a lawsuit to compel her to do A. Is that material to our assessment of whether or not that co-trustee should be removed?
No, I think, Judge, it's an abuse of discretion standard. Judge Butner heard the evidence. First off, we're going to take the position that Marta's disagreements with her brother Eric all had merit. Eric wanted to open up a bank account in Arizona that required Marta to travel from California rather than sign the signature cards by mail. That was a legitimate disagreement, but that's an example of Eric trying to exercise his authority over his sister. And Judge Butner saw through Eric Schultz, acknowledged that he was a bully, and indicated that Marta Schultz had a right to remain as a co-trustee. Marta Schultz bent over backwards with her brother, agreed to a trust management plan in the very beginning of the litigation that Judge Butner ultimately adopted that ceded the majority of authority to manage this trust to Eric Schultz, because that's what he wanted, with some oversight for Marta. She has sought from the beginning to be reasonable. And this isn't a case where this is the only litigation. We had prior litigation in the Yavapai County Superior Court where Eric wanted to be appointed a special investigator to investigate his sister Marta Schultz, like he's going to be special counsel. And Judge Bluff denied that. We have litigation in California where Eric Schultz has sued his sister Marta for defamation. Eric Schultz removed the mother, Juanita, to Massachusetts, and then moved for his appointment as conservator and as the guardian. This is not some little litigation over who should be removed as a co-trustee. You want to see a pattern, you look at Eric Schultz and you'll see a pattern of litigation where he sues Martha Schultz continually. Now, what I also didn't hear, which I think is significant, is that Martha Schultz is deceased. The whole purpose of this trust, according to Eric, was to protect, not Martha Schultz, Juanita Schultz is deceased. The whole purpose of the trust is to protect, according to Eric, his mother, Juanita, and she passed away between the ruling in the trial court and this oral argument.
Is there still a trust?
There is a trust.
And does your client have any duties or obligations as we sit here today?
She's a co-trustee of the trust, and the trust provides that the assets are to be divided equally between Martha Schultz and Eric Schultz. And one of the reasons
That's a yes.
Yes, oh yes, clearly.
So it just needs to be wound up.
Wound up, and perhaps the reason they want my client, Martha, removed as the co-trustee is so she won't have any say or even any oversight in the division of the assets in a fair manner, which is also the subject of litigation in Yavapai County.
So, counsel, if we all agree there's still a trust and there's still something to be done, how is this moot?
Well, it's moot in the sense that Juanita Schultz, who is the settler and was the primary beneficiary of the trust, and was alive when Eric Schultz sought to remove Martha as the co-trustee, is now deceased. So it's our opinion that moots out his stated reason, Eric Schultz, for removing Martha as the co-trustee. As Judge Brown correctly said, I think what needs to be done at this point is you're supposed to wind down the trust and divide the assets evenly between the two children, Martha and Eric. And it's our view that Martha certainly should remain as the co-trustee because she's one of the beneficiaries of the trust and entitled to half the assets.
So you're not arguing it's moot. You're saying we've moved far enough down this line that why don't we just back off and let it take its natural course?
That would be a reasonable view of how things should be done, but without casting stones on Eric, I can tell you that's not his view. His view is nuclear warfare. He's never going to back off. He wants to litigate with Martha every opportunity he has. He goes for the most extreme remedy, which is to remove his own sister as a co-trustee of his parents' trust because she has the nerve to sometimes disagree with what he says. And that's what Judge Butner saw in this litigation, and that was the conclusion that Judge Butner reached when he determined.
Can I take you back and talk about mootness again?
Of
you
course.
argued mootness. Is that right?
I did.
And it's a doctrine. It has elements. There's case law on it. Do you continue to maintain this case is moot and that there's nothing for this court to do?
I think the removal of Martha Schultz as a co-trustee for Eric Schultz's stated reason, which was to protect Juanita Schultz, is moot by virtue of Juanita's death. Yes, the trust still exists. The assets of the trust are to be divided equally between Martha and Eric.
Can we appoint some independent third party to come in and wind this thing up? Does this court have that authority?
Judge, we had thought in the beginning when we filed our response to their petition to remove Martha that that was an excellent idea. And we thought perhaps the way to do this when you have this blood warfare between a brother and a sister is to appoint somebody independent. But unfortunately, there wasn't enough assets really at stake in this trust to warrant economically the appointment of an independent trustee. So I guess in answer to your question, it probably hasn't changed today versus what it was, several years ago when we decided there wasn't enough money.
So you made an economic decision, not a legal decision.
We made an economic decision not to press for the removal of Eric and Marta as co-trustees and appoint a third party. We thought initially that made some sense, but we thought economically it made no sense. What you've got is just a fight with Eric, where Eric says it's his way or no way. And that's what the Yavapai County Superior Court has observed in a number of pieces of litigation with Eric. Eric hasn't gotten his way in that litigation, and now we're sitting here in the Court of Appeals with the mother deceased arguing over again whether his sister Marta should be replaced. And I'm going to use that as an opportunity to talk about an award of attorney's fees. Judge Butner got it all right, except Judge Butner probably, and I'm not in his head, but probably thought if he awarded attorney's fees, it was just going to be an incentive for Eric to continue on with this battle and take it up to the Court of Appeals.
Let me ask you something. Are you seeking those attorney's fees from the trust or from Eric?
I think the court has the right to award us attorney's fees from either the trust or Eric, but I think it's more appropriately to be paid by Eric, because if it comes out of the trust, she's paying half the attorney's fees herself.
So that's your position. That's what you're seeking?
I am. We think the award of attorney's fees should be against Eric Schultz. Perhaps such an award might dissuade him from the appeal you may see in a couple of years on gosh knows what issue.
Well, let's be clear on this. You are not here today seeking relief from the trust. You don't want fees from the trust. Is that true or not true?
We would prefer the fees to come out.
Prefer. Are you seeking relief from the trust or not?
I would think if there's going to be any award of fees that come out of the trust, there should be some provision for an offset that Marta doesn't end up having to pay half those fees. That's my answer to the question. I mean, if you awarded $10,000 in fees that should come out of the trust, then in essence, Marta is paying $5,000 of those fees.
And do you have any authority for that? Or that maybe the Uniform Act, someone has used the fee provision that way?
I think the court's got the discretion to interpret the act, looking at the comments, to do what the court believes is fair. Our initial position, Judge, is we think Eric should pay the fees. Eric's the one who sought to remove Marta as the co-trustee. He was unsuccessful. I didn't hear the argument about Eric was somehow the prevailing party, but he wasn't. My client was the prevailing party. She got the award of costs. Judge Butner got it correct, except I think he took a diplomatic view and didn't award attorney's fees to Marta with the thought that we would end up here today, but we're here anyway.
So let me just clarify very briefly. Your position then is that you're seeking an attorney's fees award from Eric directly, or in the alternative from the trust with an offset to Martha.
Yes, Judge.
So if we find that the law does not allow us to exercise that second option, which is fees to come from the trust with an offset to Martha, then Eric.
That would be our position, and I think the statute 14-1104 provides for an award either against a trust or against Eric. My client certainly prosecuted the defense of this case in good faith. She prosecuted the defense of all the lawsuits that Eric has sued her in good faith. And Eric is just a litigious person. And
Clarify, you're seeking fees, you're arguing that the trial court should have given you fees, and you're seeking fees on appeal.
yes, we are. We definitely are seeking fees
Did you
on appeal.
request the fees at
Yep.
the Superior Court level?
Yes, yes, and Judge Butner elected not to award fees. And
You would agree that that's a discretionary call?
and we would not have appealed it if they hadn't filed an initial appeal. But because they filed the initial appeal, we filed a cross appeal on that issue. I thought that was fair and a legitimate position. I respected Judge Butner's view of why he elected not to award attorney's fees. It would have just been throwing gasoline on a raging fire, so he elected not to do it. But the fire burnt the building down anyway, so here we are, and we filed the cross appeal on attorney's fees, which I think he could have awarded to us. He certainly had the discretion. We asked the court, because we did defend the case in the trial court in good faith, because she did prevail, because Judge Butner made a number of remarks that are quite illuminating about Eric Schultz being a bully. You can't cooperate. Judge Butner made a comment that we cited in the brief on more than one occasion. Eric is one of those guys that tries to control everything, and he tries to bully Marta around. And that's been apparent in this litigation to me by listening to him testify, engaging the way he acted under certain circumstances. That's Eric Schultz.
Let me ask you, did your client participate in a mediation in which she agreed to open a bank account for the trust?
There was a stipulation, and she had agreed to it, and then at the end, Eric wouldn't comply with the stipulation. Had to take the case to trial. I'm not even sure why the case originally went to trial, because they did a settlement conference, entered a stipulated order that he didn't comply with.
Well, let's take two steps back. The mediation agreement provided that your client would open a bank account for the trust. Is that accurate or not accurate?
I think they were going to open up a bank account. They did ultimately open up a bank account. The question is, which bank was it going to be open to? Did she have to come from California? She's a teacher and take time off to open up the bank account, or could she use the mail? And that was the big issue. Eric wanted it opened up that required the signature cards being signed in Arizona.
So yes, your client agreed to open up a bank account for the trust.
I believe that's accurate.
And how long did it take your client to open up that bank account? In months?
It took several months. Okay. I can't tell you specifically because
More than a year?
I don't know if it was more than a year. I'd probably have to turn to Mr. Diener to tell me that. But I think that. I'm sorry?
Does it matter? If it took 3 years versus 2 months?
Oh, I think if it took 3 years, somebody might say, gee, why are you dragging your feet so long? But I don't think it ever took 3 years. I don't think it took 2 years. I don't think it took any extraordinary amount of time. I think if that's what they've got, if that's what they've got, that she argued over opening up a bank account that required signature cards being signed in person versus signature cards being signed by the mail, I'll submit to you that that isn't grounds to remove Marta Schultz as the trustee. And if Judge Butner had thought that that was such a terrible sin, then I suppose he could have entered an order saying, I'm going to remove her as the trustee. But Judge Butner heard the evidence and concluded that that wasn't the case. I'm going to reserve my last 12 seconds. Thank you.
May I answer that question for the court? 18 months. 18 months to open an account. All of it attributable to Marta's delay. Refusal to sign documents and return them, calling up the bank and initiating a customer service complaint against the credit union official that was charged with trying to assist them in opening the account. 18 months.
Counsel, let me ask you, are we to consider these satellite litigations?
No.
Apparently a defamation lawsuit, is that right, in California, and
No.
then something else in Yavapai County, both initiated by your client?
No, the California litigation we set forth, given the limited time that I have, let me just direct you back to my reply brief on that issue. I set forth the California Rules of Procedure and the Arizona Supreme Court Rules of Procedure that prohibit the mentioning of decisions and actions in other jurisdictions when those are not published. So no, this court should not consider that. With respect to the satellite litigation currently in play in Yavapai County, I do want to mention, it raises the point. I've heard a characterization of Eric, which is a mischaracterization. He may have been the initiating party on the filing of some of this litigation, but I would request that you look at those captions. You will see objection followed by cross petition. Objection followed by cross petition by Marta. And Marta initiated the current proceeding in Yavapai County regarding the disposition of proceeds from the sale of trust real property.
Go ahead to your point. I'm sorry, I don't want to take away your last minute. You had points that you were...
The only other point I would like to make is, with regard, they keep mentioning prevailing party, we're the prevailing party, we're the prevailing party. I look at 11004 and I don't see prevailing party. The last portion of subsection A is regardless of whether the defenses or prosecution are successful.
But it says entitled to reimbursement from the trust.
Oh, yeah,
Are you
that's
asking-
subsection B. Yeah.
Yeah, subsection
right.
A is from the trust.
The trust. Okay, and then, but the court may order the reasonable fees, but still there, it doesn't mention, I would suggest that you're looking more at whether or not so much that they're the prevailing party, but whether or not they prosecuted or defended in good faith. One last thing I really want the court to consider, I'd like to come full circle to where we started, the policy argument concerning removal. I would suggest to this court that the legislature took into account the cost of continuing litigation between co-trustees when removal is a practical solution and solves the problem. Thank you.
Thank you.
I've been educated. The Massachusetts court entered an order regarding the bank account in Arizona. The account in Arizona, and this came out in the trial, couldn't be opened based on a Massachusetts order. So our office prepared our own stipulation that opened up the account in Arizona. I think that addresses the delay. There was delay, but it was in large part because of the fact that the Arizona court, the bank couldn't rely on the Massachusetts order. You've got the briefs. You've heard our position. Thank you very much for your time.
Thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We'll take a brief recess to prepare for the next argument.